All right, so welcome back to our latest of the question and answer videos. So some good questions for this week, which I will get to right away. So first question, seems as though the Electoral College has failed to act in the way the framers intended it to. Every single time since its inception. Is the idea of having a well-functioning electoral college even possible? What would it take? If you go back to the Electoral College, it envisions this section of the Constitution envisions, chosen as follows: each state shall appoint in manner as the legislature thereof may direct, number of electors equal to the number of senators and representatives, but no senator or representative, a person holding an office or of trust or profit under the United States shall be appointed an elector. And you can kind of get a sense of how the framers intended the Electoral College to work from the area that I have here in red. The idea was to create or to have appointed independent people who would uh, sort of look at the national interest. Obviously, this has never really happened in the United States except for with George Washington's election. And I think getting back to the question, is the idea of having a well-functioning electoral college even possible? At this point, the answer to that is it's just not possible. And states have increasingly recognized this. There are now 36 states that have, remember the Electoral College, the idea was that these people would be independent. There are 36 states that have laws of various types that bind electors to vote for the person to whom they were slated. So like in 2020, a Biden elector would have to vote for Biden, even if they decided that the Electoral College that Bernie Sanders was the better option, or a Trump elector would have been bound to vote for Trump under state law, even if they thought Pence would be the better figure. So at this point, it really would be a better situation for all concerned, even if the winner were chosen via electoral college, that the idea that any pretense that this was an independent body was largely moved away. I mean, if you think back to the riots in the January 6th riots, I mean, they were targeting an event, the counting of the electoral votes, but that's exclusively a formality under the current system. So, I think the answer to this question is that this is a section of the Constitution that simply cannot be salvaged as the framers intended it to work, because the existence of party slates for electors means that you not only will not have independent people, but you will have super non-dependent people as electors. Second question regarding the impeachment of William Blount, which is, again, it's a really odd case. Speak more about why there was disagreement over whether legislators could be impeached, why some felt that this was, relevant to Congress, and how would the House or Senate go about expelling members? That issue is addressed in the Constitution. Each House of Congress may determine the rules of its proceedings, punish its members for disorderly behavior, and with concurrence of 2/3 expel a member. And so this clause, I think makes the impeachment thing, it's a particularly odd approach. So first of all, when has this been addressed? So I have the list here on the right. There has not been a member expelled from the Senate since the Civil War. There have been a number of cases where senators were about to be expelled or might very well have been expelled and then resigned before the expulsion. Al Franken a few years ago might be an example of this. Bob Packwood, who was a senator from Oregon in the 1990s, who was accused, very credibly accused, by a number of former female staffers of just sort of egregious forms of sexual harassment. Is another. He resigned before he was expelled. So it's certainly not the case that these these members have been able to, the process has been used. What appears to have motivated the Blunt issue was a confusion about whether, because he was also accused of a crime, whether the fact that he was accused of a crime would require going the impeachment route or simply going the expulsion route. And because he was expelled and because he sort of never came back, this kind of created the precedent that with regards to the expulsion of legislators, advocates do not need to go to the extra step with regards to an impeachment. And of course, impeachment, remember, requires conviction of by a 2/3 vote. That's the same level as the expulsion provision of the Constitution. What was the purpose of the Supreme Court before Marbury versus Madison? Not very much. The court, in its first 15 years or so first 12 or so years of existence during the 1790s, averaged only around one decision per year. It was close to inert. Um, Most of these lawsuits, in one way or another, dealt with litigation against states, the state governments, which would sort of kind of pushed it into the court. But there really was in the 1790s only one significant decision. This case called Chisholm versus Georgia. The court, one of the justices recused, and so it was a 4-1 decision, where the court held that Chisholm, who claimed that the state of Georgia owed him money. You can sort of read the facts here as a result of a contract entered into during the Revolutionary War, and he wanted to sue for that in federal court. And the court in Chisholm said that was appropriate. That decision is essentially annulled by the 11th Amendment, which grants two states, except under certain limited exceptions, most of which were developed in the 20th century, a concept called sovereign immunity, which means that they can't be sued without their permission in federal court. So, the sum total here is that the most significant decision that the Supreme Court makes pre-Marshall gets wiped out by a constitutional amendment. So, this is a body that is simply not active at all in the 1790s. Another Supreme Court related question. My question is, why wasn't Jackson impeached for not backing up Marshall? Isn't the government supposed to be united? He made a fool of the Supreme Court, which weakened them. That's absolutely true. And isn't that grounds enough for impeachment? And I think the lack of action against Jackson is a good reminder of precisely what is and isn't impeachment. So here are the relevant sections from the Constitution regarding the impeachment clause, and then the kicker is the president, the vice president, and all civil officers of the United States shall be removed from office on impeachment for and conviction of treason, bribery, and other high crimes and misdemeanors. Now we know what treason is, we know what bribery is. So Jackson was not guilty of either of those. Was he guilty of a high crime or misdemeanor? No one really knows what that is. But the nature of impeachment is it's intended to be a political process. Right, so you need 2/3 votes in the Senate to convict, and as we just saw in the Trump impeachment, this is a situation in a normal criminal trial. All of these jurors would have to recuse themselves because they knew the defendant and they had pre-existing biases either for or against the defendant. So the thrust here is that the reason that Jackson is not impeached is that there is not the political will to impeach him, that most members of Congress, actually of both parties, is quite shamefully at this point, basically agreed with him that the country would be better off if the Native Americans were kicked out of Georgia and forced to resettle. And certainly they weren't willing to stake their political careers on impeaching Jackson for a position with which they actually agreed. And so, yes, on paper, Jackson should have been impeached, should have been removed. This was defiance of the Supreme Court. It was a failure to execute his oath of office to uphold the Constitution. But in the realm of actual politics, where impeachment is large, the definition of an impeachable offense is largely a political one. The Congress wasn't interested in going there. Why did the North care so much about preventing the spread of slavery? I understand the abolitionist moral argument, but I don't see, and I think this is correct, the moral argument, at least inherently, as much of a constitutional case. But weren't the abolitionists not much more than a minority that wasn't well received by much of the North? And this is true. for I think for the 1820s, 1830s, and into the 1840s. But this changes in the 1840s in the North. And this is a map, it's sort of a northern newspaper right after the war with Mexico. And what you'll see up at the top here, map of U.S. states and territories, possessions and aggressions of the slave power. This concept of a slave power, which was capital S, capital P, usually in the 1840s, was a much more popular vision in the North than abolitionism was. I mean, abolitionism probably never had majority support in the North until during the Civil War itself. And the idea of a slave power, and this was, I think, a widespread belief in the North by the late 1840s, early 1850s, was that a group of slavery fanatics, based in the South, represented by Southern senators and legislators, were intent on undermining the Constitution, destroying the kind of core basis of American self-governance, solely to protect slavery and advance the cause of slavery. So it's this sense that not just that slavery is morally wrong. Again, most Northerners by the 1850s thought that slavery was morally wrong, even if they did not see African Americans as socially or legally equal. Um, but the core of this argument really wasn't about the enslaved Americans at all. Rather, it was about this idea that the South, because of its attachment to slavery, was perverting the constitutional liberties of all. So in some ways, it's a self-centered concern by Northerners with the idea of slavery and the role of slavery in the American Republic. Does the idea of states and counties in America declaring themselves gun sanctuaries against gun laws or sanctuary cities against deportation and immigration laws represent a modern version of nullification? The answer here is yes and no. It certainly is yes in the idea that these both sort of the gun sanctuaries on the right and the immigration sanctuaries on the left are kind of an aggressive expression of federal power. But the critical difference between these two instances and what we saw with nullification, say with regards to the tariff, is that both of these areas, so immigration enforcement and gun enforcement, relate to the police power. And the police power in the United States has been interpreted as falling to the state. So Article 10 says the power is not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. There is no national police power that's granted to the federal government. Now, it's true we've had the FBI that's created in the 20th century, and the Marshal Service earlier than that. And these are drug and enforcement agency, and these are agencies that perform some of the functions of criminal justice, ICE, with regards to immigration. But nonetheless, there never is a federal police force, which is something actually where the U.S. is distinguished from many European countries, from Israel, and from many Asian democracies. And so in this respect, basically, what the advocates of the gun sanctuary cities or the immigration sanctuary cities are saying is, look, these activities involve the police power. The local police has to choose to enforce these laws or not, and that's a decision that under the Constitution is a power that's under the Constitution is reserved for the states, not for the national government. And so the national government can make a request, but if the states decline that request, that is not an improper exercise of state power. So, you could argue that this is nullification. Sort of, conservatives do argue it sometimes on the immigration issue, and liberals do argue it sometimes on the gun issue. But it does reflect this longer tradition of that police powers in the United States are primarily a state rather than a federal power. So that's what we have for questions for this week. Hope everyone is staying safe, and I will see you next week.